He's dead, Jim. Dirt and filthy murderer.
Gil, stop it!
He murdered him, Gil.
The Law and Mr. Jones. Created by Cy Gomberg. Starring James Whitmore.
I'm not guilty.
Hey, Jim.
Oh, hi, Gil. Come in.
Just heard from your opposition. The lawyer the boy hired from the city. Just made reservations at the hotel.
Abraham Lincoln Jones.
You know anything about him?
The Sunday supplements are fond of calling him the champion of the underdog.
Well, he's not staying at my hotel.
Oh, yes, he is, Gil. When Mr. Jones gets here, I want him welcomed to a nice, peaceful, quiet town.
Quiet. Peaceful. That window was busted till this morning. They fixed it just before you got here. Well, go on, check it. The putty's still wet. Baby, they're giving you a snow job. Look, do you know what this is, man? It's a canary cage. And out there are 5,000 quiet, peaceful cats just waiting for the door to open. They got me on 6 counts, man. First-degree murder, second-degree murder, manslaughter first, manslaughter second, aggravated assault, and conspiracy. Baby, they're gonna throw a rope around my neck.
Sit down, will you?
Look, I don't think I'm getting across to you, Charlie.
Down. Please.
All right.
Thank you. Some things I want to tell you.
I'm all ears, sweetheart.
First of all, my name isn't Sweetheart, it's Jones. Mr. Jones.
Mr. Jones.
Thank you. And you're going to knock off that beatnik gab until this trial is over.
Anything else, Mr. Jones?
Yes. You're going to get into some decent clothes if you've got any. If you haven't, I'll get some for you. And you're going to shave off that beard.
I get your message, Mr. Jones. Impress the jury.
Yes, that's right. And last but not least, you're going to drop that defiant attitude because it doesn't impress me one bit. And it could hurt you in court.
Nobody's gonna scare me. I got a right to wear a beard, and I got a right to talk any way I like.
Sure you do. But not as my client.
Mr. Jones.
Yeah?
I didn't hit that guy.
I know, you told me. The DA claims that you were a part of the group that did.
But I wasn't with that bunch.
Fine. You know whose word they have for that? The word of a bearded, crazy, wild kid without a home. No roots, no nothing. An ideal subject for suspicion. You, Ruddy.
Mr. Jones, I'm not wild. I just like to ride a bike. It's pretty much what I said it was in my letter.
Your letter. You know, that's why I'm here. That was a wonderful letter. Incidentally, who wrote it for you?
Well, I did. Well, I did. I'd like to be a writer someday.
Well, in certain quarters, that isn't going to help you much either. All right, Ruddy. The DA says he has a witness who heard you threaten to run over Officer Willard when you ran through this town a few weeks ago.
That's a lie.
Is it?
Sure, I've been through the town a couple of times, but I've never even said hello to anybody.
Good.
Mr. Jones, can you help me?
I can help you get a fair trial. Come on, let's talk.
I've typed all your notes for the trial tomorrow, Mr. Jones.
Oh, thank you, Miss Spear.
Boy, it sure is nice to be up here after the city. So quiet.
Yeah. It sure is.
All right, Mr. Jones, the court will hear your motions.
Thank you, Your Honor. For reasons which I hope need no elaboration, I move for a change of venue.
Your Honor,
Motion denied.
Your Honor, the hostility in this town...
there's no hostility. This town is calm, quiet, orderly.
At the moment, yes, Your Honor, but deliberately so. Your Honor, I think that these back issues of the local press will best indicate the true temper of this town.
The motion has been denied, Mr. Jones.
Exception. Your Honor, for what could at most have been an accident, my client stands indicted on 6 charges from conspiracy to murder. Now, I have filed a demurrer to the first 4 counts.
Your Honor, it is up to the jury to decide which crimes have been committed.
Demurrer overruled, Mr. Jones.
Exception. Yesterday afternoon, I petitioned this court to grant a discovery for the names of the prosecution witnesses and what they would testify to. Now, without that information, I can't possibly prepare a proper defense.
Your Honor, the people's witnesses have a right to be protected against vengeance and intimidation.
From whom? The man's in jail, denied bail. How could he possibly hurt your witnesses?
He is only one of a vicious gang of thugs who can roar through this town any night they choose and do murder.
Your Honor.
Gentlemen, you will meet the witnesses at the proper time, Mr. Jones. Motion denied.
Exception. Your Honor, I make my next motion with the greatest reluctance. On the grounds of prejudice and bias, I move that the court disqualify himself and a judge from another county be brought in to preside at this trial. I do not charge this bias as deliberate. I merely point out that the judge and the victim, Al Willard, were friends for many years. They were classmates together. I stand at my formal motion.
This is outrageous. Judge Talley's integrity is known to one and all.
Mr. Weathering, this court needs no defense against any such charges. Motion denied.
Exception. I respectfully request that the record show my exceptions to each one of your rulings, Your Honor.
Don't presume to teach procedure to this court, Mr. Jones. Your exceptions have been noted.
Your Honor, I came on to this case rather late. I therefore move for a continuance of 60 days.
60 days? Now look here.
Continuance granted. 1 week.
See, would you check and see if that gentleman with the carnation is named Isaac Beckett, please?
I can save you the trouble, son. Yes, that's Isaac Beckett. And he's now serving his 8th term as president of the County Bar Association.
Thank you, Weathering.
Do you know this Mr. Beckett? Can he help?
Maybe. His memory's not too good.
We've met somewhere before, haven't we?
Well, in a manner of speaking, we have, Mr. Beckett. It was in 1946. I was a student of the Yale Law School. You came to deliver a series of lectures called The Conservative Looks at the Law.
I thought so. Sit down. And if I remember correctly, you took very strong exception to my views on the philosophy of Oliver Wendell Holmes.
Well, I've always been a great admirer of Justice Holmes.
And now you've come to ask me to co-counsel with you in the Ruddy case.
You're very astute, sir.
No. It's what I do in your shoes. Try to get someone the jury knows and respects to sit with me at the counsel table.
Well, it would be a tremendous help to me, Mr. Beckett.
Once a week for many, many years, at this table, Mr. Jones, a group of close friends and I sat and broke the law. Penny ante. Every Tuesday night. Al Willard sat here. Mr. Jones, it is my sincere hope that your client is convicted.
Do you think he deserves a fair trial, Mr. Beckett?
Everyone deserves a fair trial, Mr. Jones, and you'll certainly get one here. I know this court.
I found this on the seat of my car as I left my hotel this evening.
These things happen from time to time in our calling.
Is that all you have to say?
Yes.
Mr. Beckett, you can tell your colleagues in the Bar Association and the district attorney and the judge and anyone else who's concerned that I intend to use every weapon at my command to fight this attempt at legal lynching.
Yes, sir, Mr. Beckett. What can I do for you?
When the trial resumes, will you do everything necessary to secure a seat for me every day at the trial? I want to appear in my capacity as chairman of the disciplinary committee of the Bar Association.
All right, sir. I'll see to it. Yes, sir.
Thanks.
Yes, I know, Your Honor. I'm simply saying that this is another friend of the accident victim, Al Willard, and how could he possibly serve on this jury without bias?
Your Honor, please, please, please. For more than 2 weeks now, counsel for the defense has, by every fancy-dan maneuver known, sought to keep this jury box from being filled.
I am challenging for cause. This man does not belong on that jury.
Juror number 12 will be seated.
Does Your Honor realize what...
His Honor realizes everything, Mr. Jones. There will be a luncheon recess, and at 2 o'clock we shall assemble here, and this trial will proceed, and it will proceed with dispatch.
Now, to put it into simpler terms, Sergeant Kronsky, your investigation showed that the victim was hit by a moving object, probably a motorcycle traveling at high speed, which left some paint on the clothes of the victim. Is that right?
Yes, sir.
What was the color of that paint left on his clothes?
Black, sir.
Thank you, Sergeant Kronsky. You assume, Mr. Fallon. Please don't make assumptions with a man's life at stake. Answer yes or no.
All right, then. My answer is yes. It was him that threatened Officer Al Willard. I've got a good memory for faces. He was wearing a beard then.
Beard? Weren't many of them wearing beards?
Yes.
And were, in fact, many of them dressed very much alike, Mr. Fallon?
Yes.
Well, then how can you be so sure it was the defendant? Couldn't you have been mistaken?
I'd recognize him anywhere. Are you calling me a liar?
I'm not calling you a liar.
The people rest, Your Honor.
Your Honor, in view of the fact that the prosecution has failed to prove a prima facie case, I move for a directed verdict of acquittal.
Denied. Call your witnesses, Mr. Jones.
The defense has but one witness. The defendant, Ned Ruddy. For you, Mr. Ruddy, I have one question. One question only. You'll recall that Sergeant Kronsky testified that the victim, Al Willard, was hit by a moving object, probably a motorcycle, traveling at high speed, which left some black paint on the clothes of the victim. My question to you is, what color is your motorcycle?
White.
White. Your witness?
Mr. Ruddy, in your experience as a motorcyclist, hill climbs and the like, you must have met lots of other young men with similar tastes.
Objection.
Your Honor, I merely wish to prove that defendant was part of the group, part of the conspiracy that resulted in homicide.
Well, and you know you have no right to do that, Mr. Weathering. It's beyond the scope of direct examination.
Mr. Jones, I see no reason why the question should not be answered.
By reason of constitutional interpretation, Your Honor. In almost every state in the Union, the upper courts have unanimously held...
It is not unanimous in this state.
May I be allowed to give the reason for my objection? Your Honor, I, in direct examination, asked the defendant one question and one question only. Cross-examination is not permitted to go beyond the scope of that one question.
Overruled. Answer the question.
Your Honor, I must respectfully insist.
Be seated, Mr. Jones.
Your Honor, you're asking the defendant to help convict himself.
Sit down, Mr. Jones.
Your Honor.
Sit down, sir. Mr. Jones, we are here to get at the truth.
But under proper rule of law, Your Honor.
I repeat, sir, we're here to get at the truth. This court is perfectly capable of conducting a trial. I shall ask the question myself. Do you know the motorcyclist who hit Officer Willard?
I protest, Your Honor. That question is even more objectionable when asked by the bench than when it was asked by the prosecution.
Mr. Jones, sit down and keep quiet.
Your Honor, I cannot agree to my client's answering an improper question.
Bailiff, please seat Mr. Jones. Answer the question.
Your Honor, I must respectfully...
Answer the question and answer it now.
I don't remember the question.
Read the question.
Did you know the motorcyclist who hit Officer Willard?
Your Honor, I must object on the grounds that my client has not been adequately advised as to his rights against self-incrimination.
The attorney for the defense will sit down and remain seated, or it will become necessary. Sit down, sir. Mr. Jones, I promise you the question will be answered. It will be answered. Your answer, please.
Objection, Your Honor, on the grounds that it is against
Bailiff.
the established rules of evidence.
Answer the question.
Your Honor, the question is incompetent, irrelevant, and immaterial.
Both attorneys and the clerk will approach the bench. Mr. Jones, I want you to know that I consider your conduct contemptuous, and I shall hold you in contempt, sir, unless you sit down and keep quiet and allow this trial to proceed as I direct.
Your Honor, the conduct of this trial has convinced me that my original motion for disqualification of the judge was very apt. I therefore respectfully move that you declare a mistrial.
Your motion is denied, sir. Return to your places. The clerk will please read the question once more to the witness.
Did you know the motorcyclist who hit Officer Willard?
Answer the question.
I respectfully
Very well. It's obvious that the defense counsel is determined to continue obstructing the progress of this trial. The result may very well be that he will succeed in prejudicing the jury against his own client. Rather than allowing that to happen, I shall declare a mistrial. Mr. Jones, I want you to know this. The defendant will be tried again, and in this county and by this court. Meanwhile, sir, I am holding you in contempt. Kindly present yourself before this bench tomorrow morning at 10 o'clock for sentence.
Let's go, C.E.
Is Mr. Jones going to have dinner with us?
No, he seems to want to be by himself. C.E., what do you think that judge will do? Fine, Mr. Jones?
Yeah. Yeah, I do. You know, he could even send him to jail.
Oh, no.
But you know, the thing that worries me is old Hawkeye from the Bar Association. I sure hope he doesn't bring disbarment proceedings against Mr. Jones on top of the contempt.
Mr. Jones, will you approach the bench? Mr. Jones, you have been cited for contempt of court. I shall now sentence you. But I want you also to know that I intend to bring your behavior in this courtroom to the attention of the disciplinary committee of the Bar Association for appropriate action.
Your Honor, as chairman of the disciplinary committee of the Bar Association, may I have the privilege of addressing the court?
By all means, Mr. Beckett. Mr. Jones, you may be seated.
Your Honor, I have sat in this court every day since the case of the people versus Ruddy began. as an official observer for the Bar Association of this county. Prior to the trial, it came to my attention that Mr. Abraham Lincoln Jones was firmly determined to do everything in his power to block the orderly presentation of the people's case. Then, when the trial began, I saw Mr. Jones put this determination into action. I saw him try for a change of venue, for a reduction in the charges of indictment, and for the self-disqualification of the court. In fact, I saw Mr. Jones use every device, every tactic, every stratagem known to courtroom practice in an effort to save his client. Time after time, I watched while Mr. Jones balanced precariously on the edge of the abyss of contempt in an almost fanatical determination to prevent what he construed to be a miscarriage of justice. I would not presume to question any ruling this court has made, but if, because of his behavior in this court, Mr. Jones is brought up on charges before the disciplinary committee of the Bar Association, I shall gladly offer my services in his defense. Today, Your Honor, there are far too many members of the bar unwilling to fight to professional death for a client whom they believe to be unjustly accused because of personal fear. However, there are times when we must, all of us, take risks. I thank the court for its indulgence.
The conduct of a trial is a responsibility that this judge understands and has always endeavored Mr. Clerk, let the record show that the citation for contempt was dismissed.
Thank you, Mr. Beckett.
I think you'll get your change of venue. He's a good man. Incidentally, my views of Oliver Wendell Holmes' philosophy remain unchanged.